this meeting to order. Good morning and welcome to Open Caucus, today focusing on the protection of private data. I'm Art Eggleton, Senator from Toronto. Beside me is my co-chair, Senator Raymond Saint-Germain from Quebec. Now, the Open Caucus is a forum for discussion on issues of national importance. This meeting is co-sponsored by the Independent Senators Group, ISG, the Independent Senate Liberals, and the Government Representative Office in the Senate, together representing the majority of the members of the Senate. This, however, I wish to emphasize, is a non-partisan discussion. It's open to all parliamentarians from both houses of Parliament, staff, media, and public. As highlighted by the recent Facebook and Cambridge Analytical data abuse scandal, Canada needs to enhance its statutory protections of private data. Unlike the European Union, who now have strict proactive privacy regulations, Canada's federal privacy laws operate on a complaint-based basis. In addition, Canada's privacy laws do not currently apply to how political parties collect, store, use, or misuse private data on voters. In an increasingly digital world, it can be challenging to understand the scope and nature of data breaches that have or may occur. In light of this growing concern, we ask our expert panelists what type of regulation is needed to ensure Canadians' private data is managed ethically, transparently, and with informed consent. And how should Canada's federal privacy laws be extended to include political parties? On logistics, we have coffee or tea available at the back of the room, as many of you would have discovered by now. Translation, I think my colleagues know how that operates, but for those in the audience, there are headsets located at your chair. Channel 1 is for English, I understand Channel 2 is for French. And talking about audience, we do encourage audience participation. If you would like to make a comment or ask a question, you can get up to 3 minutes at that microphone, which is directly opposite me. Just let Sarah, who is our Open Caucus coordinator, hands up there, Sarah? Okay. Just let her know, and she'll slip me a piece of paper and who wants to say something. So now, et maintenant, Senatrice Saint.
And now, Senator Saint-Germain. Thank you, Senator Eggleton. Thank you to my colleagues and here. It's a busy time right now, and we appreciate that you've made this event your priority. Thank you to our audience as well. You've come out in large numbers today. According to results of a survey taken of Canadians in 2016 on privacy, 90% of Canadians are worried about the protection of their personal data. Among those surveyed, 74% believe that their personal information is less well protected than it was 10 years ago. Canadians do not have the explicit right to ask that search engines correct information about them, while the European Union does so. It has the right to be forgotten. We have the Project Bill C-74. We are studying this currently. It would require Canadian businesses to tell how they collect personal data and how it would be protected. The situation is complex. Currently, Canadian businesses gather considerable information on Canadians, and this is sometimes used as a product to be sold. We need programs and public services. This is a laudable desire, but this information should not be used for other purposes. Even if we currently have a legal framework in Canada that should protect private information, personal information, it is not always protected. Beyond protecting laws, we need to develop the technical capacity that would allow us to better implement current standards. We must also wonder, as a society and as citizens, What principles are involved when we're talking about protecting private information? Should we ourselves be in control of this information? Today we have a list of 4 panelists who will be telling us more about these questions. Without further delay, let's let our panelists speak. Senator Eggleton.
4 panelists today who bring different perspectives to this particular subject. And let me introduce our first one who will say a few words, and that's Daniel Therrien, who was appointed Privacy Commissioner of Canada in 2014 after 3 decades serving Canadians as a lawyer with various federal departments. As the Privacy Commissioner, he investigates complaints filed by Canadians who feel their privacy rights have been violated and reports to Parliament on whether there have been a violation of Canada's 2 federal privacy legislations. The overarching goal of his mandate is to increase the control Canadians have over their personal information. Mr. Therrien.
Merci.
Thank you very much, Senators Eggleton and Saint-Germain, and to the other senators at the table here today. Thank you. You described the problem in a very general manner. I'll be pleased to answer questions that go beyond these initial 2 questions. I believe that I should focus my comments on Bill C-74 in particular and its repercussions given the Cambridge Analytica and Facebook incidents. I'd also like to talk about privacy with regard to the private sector, businesses. We published a study in the last fall about this matter, but of course it did not concern the public sector. I would be happy to answer questions about the public sector as well. Allegations about the non-authorized use of 50 million Facebook users' personal data raised alarms. A crisis is developing with regard to privacy law. Not only was consumers' trust undermined, but that of citizens with regard to democratic processes. It is clear that personal information can be used for much more insidious purposes than marketing. The Office of the Commissioner launched an official inquiry into Facebook. We'll need to be impartial and not anticipate the results of this inquiry. However, allegations shed light on shortcomings in our privacy laws. Canadians want to take advantage of the countless benefits of the digital economy, but they rightfully expect that they can do so with their rights being protected by effective laws, that their private information will not be used against them. Self-regulation is not sufficient. We are not in a fully self-regulating situation in Canada. We do have laws, but they do not suffice. And even major tech businesses, Apple, etc., have stated as much. Canadian laws with regard to privacy are outdated and no longer adequate for the task at hand. We therefore urgently need to modern laws that will protect us as citizens and as consumers. And if you have the PowerPoint, I am now on slide 2. Currently, for example, political parties are not subject to privacy laws. This situation is unacceptable in my opinion. Canada must also act given the seriousness of the allegations that see privacy information of electors being used for analysis that would have influenced democratic processes. We need to subject political parties to privacy laws. Now, some administrations in Europe, New Zealand, and British Columbia already recognize that political opinion is sensitive and must be protected. It's the case in Hong Kong, too. And I've heard federal politicians say that, yes, political parties must be subject to privacy laws, just as businesses and government departments are. Other politicians, for example, Minister Ryerson, Minister Gold, believe that this would affect communications, would harm communications between the parties and their electorate. They seem to think that political parties aren't in the same situation as businesses. Now that's possible, but I have yet to see the proof. This proof was not presented either to me or anywhere in the public sphere, in the public domain. Now, democracy is still flourishing also in administrations where political parties must obey privacy laws, for example, in the European Union in general, and in Canada in BC. I'm now on slide 3. It doesn't really matter which particular law with regard to privacy. It could be the Elections Act, the PIPEDA, Personal Information Protection and Electronic Documents Act, or another law. What does matter is that personal information principles are recognized, the internationally recognized personal information principles be included in national laws, and that an independent party, possibly our office, which has the necessary expertise, have the right to ensure that these laws are upheld.
Personal information is central to new online business models and advances in the use of big data and artificial intelligence, which are necessary for Canada's economic development. Trust needed to allow the digital economy to flourish hinges on having an appropriate legal framework. First and foremost, a modern law would better protect Canadians, but it would also offer companies the legal certainty they need in an increasingly complex environment, a certainty they do not have when relying on an ocean of consent that is so stretched as to become meaningless. We need legislation that ensures Canadians provide meaningful, informed consent for the collection and use of their personal information. But consent will not always be possible in the new world, where data may be used for multiple purposes not always known when it is collected. In these situations, organizations have an important role in responsibly managing personal information. With that in mind, the law should allow my office to go into an organization to independently confirm that the principles in our privacy laws are being respected without necessarily suspecting a violation of the law. These inspection powers exist in other regulated industries. Why isn't our personal information worthy of the same protection? The time has also come to provide my office with the power to make orders and issue fines, helping us to more effectively deal with those who refuse to comply with the law. I'm very pleased that a parliamentary committee, EFI, recently issued a report calling for comprehensive changes to the federal private sector privacy law, and I call on government to act on that report. An overwhelming majority of Canadians are concerned, as Senator Saint-Germain said, about how the digital revolution is infringing on their right to privacy. And recent events obviously will only reinforce these concerns. Canadians deserve better. They deserve privacy laws adapted to the realities of the 21st century.
Merci beaucoup.
Thank you very much. Thank you, Commissioner. I'm delighted to now present you Ms. Valerie Steeves, Assistant Professor of Criminology at the University of Ottawa. She has given many conferences and written many articles on the use of network technologies by young people, and she's an expert in privacy law. She's the senior researcher in the Equality Project, a 7-year partnership funded by the Humanities Research Council of Canada, and also senior researcher on the Young Canadians in a Connected World project. Both projects regard the effects of new media.
Senator Eggleton, you started by talking about this gap between the Canadian regulatory framework and, I'm quoting it again, from the strict proactive privacy regulations the EU has recently enacted in the General Data Protection Regulation, or the GDPR. I wanted to start by saying that there's a reason why that gap exists. And I think it reflects the fact that the EU legislation has consistently been firmly grounded in strong commitments to privacy as a human right. From this perspective, privacy is not just about informational control, the kinds of things we see in PIPEDA. It's also an essential part of the democratic system. And in fact, that perspective, that privacy is a human right, has always been part of the Canadian policy discussion. When the House of Commons was drafting PIPEDA, the Standing Committee on Human Rights argued very strongly that although data protection was an essential and important part of the solution, that it was not a complete corrective, that we needed additional provisions to protect privacy as a human right to ensure that consent did not become the ceiling, that consent was the floor, not the ceiling. And I think a number of the concerns that were raised by the committee at the time have actually been borne out in the last couple of decades. That broad consent clause that we click through when we want to post a picture on Facebook opens up our data to secondary and tertiary uses, and it's been used over the last 2 decades to justify pretty well anything. And I think the Cambridge Analytica incident really illustrates well that a lack of consent becomes moot when data flows beyond our control in ways that we don't even know about. And there are reasons why we don't know what's going on with our data. Research has consistently showed that organizations fail to draft clear and easily understandable privacy policies. They're often vague. You know, we're collecting your data to serve you better kind of clauses. But that lack of transparency is complicated now by the use of algorithms and machine learning. When programmers who write these programs can't explain where the data came from and how the profile was created, it becomes incredibly difficult to use consent to give individuals control. I think the human rights perspective at the basis of the GDPR goes beyond consent because it allows us to evaluate the purposes for collection and use. And I think this is more in keeping with the original plan for data protection that was conceived of by Alan Weston in the 1970s. He tends to be our touchstone. Weston argued really forcefully that what we really needed to do was create accountability so we could come together collectively as a society and evaluate surveillance and talk about the benefits and the harms that could happen before we start to roll out all of these different systems. Data protection, the kind of things we see in PIPEDA, were supposed to only be a last step. You know, if the surveillance was deemed to be acceptable, of course individuals need the right to access their information to make sure it's secure and all those other kinds of things. And I think we're in trouble now, or that gap exists now, because we've skipped the first step. And I think our failure to create mechanisms to allow us to collectively evaluate the social benefits and harms of different surveillance initiatives has given data companies almost free rein. So the only thing that surprised me about the Cambridge Analytica story when it broke was that anybody was surprised by it at all. Because what happened in Cambridge Analytica is completely consistent with Facebook's business model. In fact, it's completely consistent with the business model of all data companies that are operating on the assumption that if they can just collect as much data as possible about as many people as possible and keep it as long as possible, then they'll be able to create profiles that will be valuable because they can sell them to other organizations that want to use that information to target and shift individual level behavior. Now, that assumption that this system works is actually based on very bad social science. There's all sorts of evidence coming out in the last couple of years that the kind of psychographic profiling that Cambridge Analytica relied on to predict voter behavior on the basis of personality traits doesn't really work well and stops working at all as soon as all political parties are using the same data and the same tactics to talk to the same people. But using this data in this way does have real-world impacts. And I'm going to talk about two. The first one is that when people know they're under surveillance, they hide. And I think that the research on kids really underlines this fact. We talk about Facebook and social media as a whole as a social graph that somehow gives us a way to see how society is interacting. Last year, we conducted interviews with a number of teens across the country that was funded, thank you, by the Office of the Privacy Commissioner of Canada, talking about the decisions they make when they post photos. And it's very clear that they're not posting information about them. They're posting photos that are going to get likes. When they do have a personal interest, they hide it. And they hide it because they don't want to be judged for it. So that assumption that the data that's being pulled into these algorithms actually creates an accurate profile is really faulty. But it becomes particularly problematic. I mean, it's bad enough with advertising, but once you're using those algorithms to make decisions about the services citizens are entitled to, about who's going to be targeted as a potential criminal and placed under surveillance, or about who's going to vote for whom, that falls apart. There are going to be all sorts of unintended consequences because that's a faulty assumption. I think the second effect that we should be concerned about is one that the Commissioner alluded to. When a practice is perceived to be manipulative or deceptive, then people lose trust in the organizations that use that practice. And again, the data from kids shows this very clearly. PIPEDA was enacted to create consumer confidence in the information marketplace. In 2000, when we talked to kids, they said, oh, I trust corporations. When it's a .com, that's my friend. I know I'm safe and I can trust that organization. By 2007, that had completely shifted, and they talked about corporations as creepy guys who are watching. That's just gross, and they shouldn't be allowed to do that, and it makes me really uncomfortable. So when companies use these kinds of practices, it has actually decreased trust. So political parties in particular, I think, have to be really careful how they use data, because they can't use it in ways that appear to be deceptive, because if they do, they could unintentionally weaken the very institutions of governance that they purport to serve. So I think there are three immediate correctives that we could consider, particularly when it comes to the Cambridge Analytica situation. The first is to bring political parties into PIPEDA. I think the BC experience with substantially similar legislation proves that that can work. In BC, it's improved the quality of the privacy policies that parties have developed, and it's created accountability, both through the complaints process and the audit process. PIPEDA, as a piece of legislation, was designed precisely to be flexible and to apply to a variety of organizational contexts. And it already has exemptions to public data, like the phone directory or Canada 411, which are important and legitimate sources of data for political parties. Secondly, I think if we do take that step and bring political parties into PIPEDA, then we should use Section 5 of PIPEDA to lay some ground rules. Section 5 indicates that data can be collected for purposes that a reasonable person would consider appropriate in the circumstances. Now, it's clear that political parties need data to organize their campaigns. I don't think anybody's fighting about that. That just makes perfect sense. But I would argue that it is inappropriate for political parties to do individual-level micro-targeting of voters because it's bad for the democratic process. So we could use Section 5 to take that off the table. I think it's especially important to do this when these algorithms use public information that's been scraped off of social media. And that's precisely why software like Nation Builder and the practice of using any Twitter contact to justify contacting that person for other purposes have all been found to violate regulations in Europe, particularly in France, under previous legislation and now under the GDPR with even stronger protections. Secondly, I think that it's unreasonable and inappropriate for political parties to sell their data, whether they disclose it or not, as they discuss in Bill C-76. It seems to me, from what I can tell, that nobody's doing that anyway. It's a bad idea. Let's just take it off the table. It's inappropriate in the circumstances. Thirdly, I think in the meantime, parties can actually get some positive momentum going if they sit down together and create a joint code of practice as a way of leveling the playing field and establishing a minimal set of protections. And I'm relying on the excellent work that's been done by my colleague Colin Bennett in that regard. Fourth, I'd like to echo the Commissioner's call for inspection enforcement powers for his office. It seems to me that the lessons of the last 2 decades show that without strong enforcement powers, the regulatory framework is seen to act less to protect privacy and more to legitimize the collection and use of data because it provides a veneer of privacy protections that do little or nothing to limit surveillance. Lastly, I think if we really want to get this right, we have to go back to basics and reinvigorate our commitment to the human rights perspective. Some excellent work was done in the late 1990s and early 2000s by the Standing Committee on Human Rights in the House of Commons. Their Where Do We Draw the Line report is still a touchstone. Certainly the Feinstone Privacy Charter that was introduced in this House is worth revisiting. But we also have the lessons of the GDPR, and in addition to that, the human rights jurisprudence that's coming out of the European Union. I think that if we step back and recommit ourselves to protecting privacy as a human right, then we will avoid many of the problems that the Commissioner so ably pointed out. Thank you very much.
Thank you very much. Two excellent presentations. We're now going to go over to this side of the table. We'll get two more. Next is Dr. Avner Levin, is professor and interim dean at the Ted Rogers School of Management at Ryerson University in Toronto. His research interests include the protection and legal regulation of personal and private information, both locally and internationally. His most recent publication is Has the Era of Privacy Come to an End? Question. In the Canadian Journal of Law and Technology. Dr. Levin.
Thank you. Good morning. I would like to start by thanking Senator Eggleton today for inviting me to participate in the panel discussion. It is an honor to be here and to participate in this important discussion. At the same time, I must say that I am here as somewhat of a cynic. Canada has been debating legislative reform for years with only minimal changes. The federal privacy commissioners, including the commissioner with us here today, have been pressing for real regulatory powers for years to no avail. There has been, I would say, widespread, all-partisan lack of action on this matter. Indeed, it seems to me we would have no law in Canada were it not for trade and commerce reasons with the EU, first with the Model Code adopted and then PIPEDA early in 2000, and now with the GDPR coming into force. Now, I am not here to talk about EU law or Canadian law in any great detail. You have other panelists much more qualified than I am for that discussion. But let us make no mistake, this is, has, and will be a question of law and of political will. And so what I am here to do is to offer you concrete suggestions that, in my opinion, you can implement immediately with respect to the regulation of Facebook and similar companies, and with respect to political parties. So let me start with that old nemesis of ours, Facebook. Those waiting for the free market to regulate the internet and social media companies will probably be waiting forever. Even the latest scandal of Cambridge Analytica has had no discernible effect on Facebook's share value or on its corporate leadership. While the stock did go down a couple of months ago, that loss has since then been regained. The market is simply and clearly telling us that privacy and data protection are not important for its purposes. But that's fine. I'm not here to advocate the free market as a solution. I believe and have believed for a decade that the answer lies in regulation. And yes, I and of course many, many others have been writing about Facebook quote-unquote concerns for almost a decade now, and nothing has changed. My first paper highlighting concerns personally came out in 2009. So let me start with what Facebook can do on its own. What it can do is change its business model, as Dr. Steeves has alluded to, and offer customers several subscription options. It can continue to offer the current quote-unquote free option. I do recognize that some people, perhaps a lot of people, just do not care that someone else is making money and changing elections by using their personal information. It probably will, Facebook, based on media reports, and definitely in my opinion should, offer us an ad-free version, for which we will pay a probably relatively low monthly subscription fee. An ad-free version does not prevent Facebook from making money from personal information. It is simply a version where you will not see ads. I imagine that some people will pay for that, just as they do for other services and apps. Facebook seems to believe that such a version will ease the public pressure and demand, such as it is, for regulation of it and other companies. What Facebook has not, at least publicly, contemplated, but what it should, in my opinion, contemplate, and what it could do on its own, or be required to provide, is what I will call here an info-free version. A version that is not only ad-free, but information-free. This would be a paid version, in which Facebook would be obligated to leave your personal information alone. In other words, such information will not be aggregated, anonymized, shared, processed, profiled. You can pick the verb of your liking. It will not be part of Facebook's business model. It is interesting to speculate how much Facebook would charge for such a version. Now, given that it made, according to public records, about $40 billion US from advertisements last year, and that it has about 2 billion users, it seems to be making about $20 US per user a year. Now, I am not a math prof, but it seems to me that if they charge me a toonie a month, then they are making their money and leaving my information alone. The question that should be posed to them is, why can they not do that? And the question to our elected representatives is, will you consider making them do that? So an info-free version for a toonie for 1 month. That is one concrete suggestion that I have for you today. Now to a second suggestion, and it is one that, again, Facebook could be doing without regulation, but probably will not. And it is about monitoring content. There are a lot of strong opinions about monitoring content, the constitutional implications, censorship questions, etc. But it is worth remembering that when it comes to policing intellectual property, then content monitoring is alive and well. Of course, that is because the law, and primarily in this case American law, requires it, in a sense that companies can be found liable for content on their platforms that infringes on someone's intellectual property. Facebook, of course, would like you to think of it as a passive wall on which you post content. Other companies akin themselves to pipes through which someone else's content flows. But these pipes are not dumb, and this wall is not a wall. If anything, it is like the walls in my faculty. You cannot post anything on those walls if it does not have the stamp of the student society on it. And if it doesn't, then it will be removed. Facebook has to be made to monitor content or face liability by law. It has to lose the immunity that it currently enjoys in the United States and on which there is no clear law in Canada. Indeed, a couple of laws in the United States have just been passed with precisely that effect. Known by their acronym as FOSTA-SESTA, Fight Online Sex Trafficking Act, and Stop Enabling Sex Traffickers Act, they simply made companies liable for sex advertisements. And wouldn't you know, but companies such as Craigslist remove such ads almost immediately. Returning to Europe and the comments by Senator Saint-Germain, Google was made to remove harmful information under the right to be forgotten decision, now part and parcel of the GDPR. What is interesting about those laws to me is that they allow internet companies to respond to a judicial regulatory decision by technological means. IP monitoring is largely automatic, and an online process has been created for the removal of personal information in Europe and those affected jurisdictions as well. So my second suggestion is to make Facebook liable for harm caused by content that is posted on its platform. Some examples would be liability for political democratic harm, for defamatory comments, and for privacy harms. And I'm happy to discuss both suggestions further during the discussion period, and I have others as well pertaining to limiting advertisers if there is interest in it later on. For the moment, however, let me turn to the second question today, and it is that of political parties and their exemption from the law. Again, there are others in Canada and around the world that have written and researched this topic, as mentioned by Dr. Steve, so I will not discuss it at great length. But my answer to the second question is simple. Of course, parties should be regulated, and it will be interesting again to see if our elected representatives will take action on this issue. I can only add to the debate that I recently collaborated with an Israeli colleague, Professor Michael Birnhack, on a research project into privacy by design, that idea that we can design privacy into technology, which is also now a principle of the GDPR. For his part, Michael researched whether privacy can be designed into the process in which Israeli parties receive and process data from the latest electoral databases in Israel and from other sources as well, from what you would consider the Israeli equivalent of Elections Canada for their political purposes. And indeed, a process was created that provided parties with electoral information while subjecting them to the law and allowing them to carry out their political activities with their databases while preserving privacy. So I would say absolutely parties should no longer be exempt from the law. Let me conclude my remarks by saying that I am cynical and perhaps somewhat frustrated, but I am here today because hope springs eternal. I look forward to the discussion today. Thank you.
Thank you.
Thank you so much, Dr. Levin. especially for admitting at the beginning and in your closing remarks your cynicism. that you're not the only one to share. J'ai maintenant le plaisir et le...
I now have the pleasure of presenting Adam Kardash, a leader in the Canadian legal community with regard to privacy and data management. He leads the National Practice Group on Privacy and Information Management at Osler. He is the senior counsel. He has been the senior counsel for several mandates, large-scale mandates concerning privacy of information in Canada. He advises clients who figure among the Fortune 500 with regard to crucial questions regarding data protection, compliance, and data governance. He regularly represents clients during inquiries held by regulators and on security matters.
First of all, I'd like to thank you, Mr. Chair, for the opportunity to speak with you today, and thank you very much for the introductory comments. My name is Adam Kardash, and I'm here at your request in my personal capacity as Chair of Osler, Hoskin and Harcourt's National Privacy and Data Management Group. And I offer my comments here this morning based on my experience practicing exclusively in the area of privacy law for the past 15 years, where, as was just mentioned, I've been advising companies from multinationals to startup across all industry sectors. And I think as a practical point, what I can share this morning is in the vast, vast majority of these circumstances, the companies that I work with, they want to do the right thing. They want to do the right thing because trust has become absolutely critical in this new data environment. I also appear and offer my comments this morning based on my role as counsel to the Interactive Advertising Bureau of Canada. It's a not-for-profit association exclusively dedicated to the development and promotion of the rapidly growing digital marketing and advertising sector in Canada. You've asked what type of regulation is needed to ensure Canadians' private data is managed ethically, transparently, and with informed consent. And as we've discussed already with some of the excellent comments and we've heard thus far, Canada's private sector is currently governed by PIPEDA. And while there are certain challenges in applying PIPEDA's fair information principles in today's highly dynamic data environment, it is clear, and certainly with respect to our day-to-day experience helping companies who want to do the right thing, it's clear that overall the statute has worked and continues to work as a very elegant and effective model for organizations to respectfully treat personal information in the course of developing and offering highly innovative and valuable service, products, and features that everyone in this room and every business in this country is using every single day. And the lasting success of PIPEDA in this regard, and the reason why PIPEDA can continue to help foster innovation, is largely grounded on key features of the statutory framework, the current statutory framework. Critically, PIPEDA is predicated on balancing the interests of individuals, important interests, critical interests of individuals, but also the legitimate need for organizations to process personal information as they carry on business every day. PIPEDA has been particularly effective because it was drafted in a non-prescriptive, technologically neutral, and sectoral agnostic fashion. So it's very well suited in that sort of drafting approach to address novel privacy considerations that may be raised by new technological developments. These novel issues come up every single day when we deal with it, so having this flexible approach to the statute is exceedingly helpful. It's also important to note that while PIPEDA is often referred to as a consent-based statute, in my experience, helping companies, and we want to explore the comment was made by Dr. Steeves about free rein. I think it's really critical. The most powerful feature of PIPEDA, its current framework, is its accountability model, which currently exists, and it provides rules that govern the entire life cycle of an organization's information processing. From the moment personal information is collected or created by an organization to the moment it's disposed, destroyed, there is no free rein. There's a whole structure in place for that. There's worthy discussion of elements within the framework, but it's not a free rein. The concept of consent is another core feature of PIPEDA's regime.
As the committee members are aware, amendments to PIPEDA were the subject of a report by the House of Commons Eddy Committee released in February of this year. The report makes 19 recommendations, including multiple recommendations for amending PIPEDA to expressly include EU general data protection regulation-like concepts. And it's worth exploring this in comments about the necessity for all of these. But among the committee's recommendations were two notable ones regarding consent. Reaffirm consent as the central element of PIPEDA and provide opt-in or express consent as the default for any use of personal information for secondary purposes. As the government considers its response to the Eddy report and potential amendments to PIPEDA, I would question whether this is in fact the right move, where in fact the rest of the world is coming to terms, and as eloquently just shared by our commissioner in this panel, is coming to terms with the limits of consent. Certainly limits as it being the sole legal basis for supporting a thriving and globally competitive digital economy. PIPEDA's consent requirement remains legally viable and practical means of authority under PIPEDA for organizations to collect, use, and disclose personal information in today's data environment using what the Federal Court of Appeal refers to as a flexible, pragmatic, common sense approach. But as artificial intelligence stands to revolutionize data processing as we know it, and Canada positions itself to be a world leader in this area, there's an opportunity to consider in what circumstances it would be appropriate to introduce an alternative basis for lawful processing to alleviate the overly burdened concept of consent and at the same time protect privacy interests. Without question, the concepts of permission and individual control of personal information will always play an important role for privacy protection. But the Ethies Committee's recommendation for a broad and unqualified opt-in consent by default requirement for all secondary uses of data seems to be moving in the opposite direction of global trends in an increasingly dynamic data environment. There are multiple use cases, we see them every single day, involving entirely legitimate business activities, such as data analytics, companies wanting to just understand their customers, the way what we've been doing for the last 40 years, 50 years. Every single business does this, small and large. If you imposed an opt-in consent, it would be at best impractical, if not impossible to implement, and I'd be pleased to share further practical details about my views in that regard. But without careful nuance and in the absence of alternative legal authorities to process personal information, I fear an amendment such as proposed by the Eddy Committee would unnecessarily stifle innovation. Now, turning to the other question as to whether Canada's federal privacy laws should be extended to include political parties, in short, my answer would be a resounding yes. In order to have an effective privacy legislative framework in this country, you need to have uniformity and consistency across all sectors, period. As a matter of public policy, it's critical for public trust that there's a level playing field in the form of consistent rules for the private sector and broader public sector, including for personal information processing activities of political parties. The bill putting forward the Election Modernization Act, if passed, would essentially require political parties to adopt a privacy policy, publish it on its website, and designate someone to whom concerns about the party's privacy policy can be addressed. There are essentially no other requirements. The bill falls far short of subjecting political parties to meaningful privacy protection like those required under PIPEDA. Unlike PIPEDA, there are no requirements limiting collection, use, or disclosure of personal information, no limitations on retention of personal information, no obligation expressly to safeguard personal information, no obligations to notify individuals in the event of a security breach. Most glaringly, and as already commented, there would still be no independent oversight of their data management practices. Seemingly, there would be no limit to what political parties could do with personal information as long as they state what they're doing in their privacy policy. In short, given the sensitive types of personal information that political parties may hold about Canadians, in my view, it remains wholly unclear as to why political parties should have such a far lower set of privacy standards to adhere to. I'll conclude my introductory remarks at this time. I thank you very much for inviting me to appear, and I'd be pleased to respond to any questions.
Well, thank you very much. So now we have the stage is set with the four commentaries that we've had from our panelists, and so it's time for questions with senators, and question maybe is supplementary question, keep them brief enough. And if you want to direct to a particular panelist, you can do so, but I would mention to panelists, if any of the other panelists want to come in and respond after that, it's quite fair to do that, as long as it's not too repetitive. Again, I want to remind the audience that Sarah over here will take your name down if you want to get involved in this whole process as well. So with that, we got quite a list here. So we'll start with Senator Massicotte.
Thank you, Chair. Our experts. Mr. Therrien, I believe last week or the week before, you testified at one of our committees about a bill that would allow banks to share information received through financial technologies. I think your testimony was pretty relevant. I think that the banks reacted to your comments by saying, we will be responsible for sharing your information. If we share it with other entities, we will ensure that they have the same standards of security. No need to worry, we can guarantee you that. However, do we have the right as citizens to proceed if ever they have not ensured the security of our information? I'll try to limit my question with regard to my answer with regard to the bank's legal liability. With regard to non-authorized release of information or leaks, there will be a new bill going into effect in November. Banks and other companies will be required to inform not only the Office of the Commissioner, but the individuals concerned whenever there is a non-authorized breach of a data breach. There can be recourses, for example, class action lawsuits in that case. So citizens will be able to act in the courts. However, what is an unauthorized disclosure of information? We go back to the idea of consent. Clients, bank clients, clients of other businesses sign by clicking or with their actual signature a contract that states certain conditions. For example, the use of information by the company in question. It would be extremely surprising if the banks did not include a clause somewhere in those conditions authorizing these banks to disclose this information. So consumer recourse would be almost nil, in that the banks would be able to draw on this clause to support their actions. Does the current law work? Well, the current law is partially based on consent. What is an informed consent, however? This goes back to the idea that companies have an extreme latitude in that they can include what they want in the contracts with regard to use of this information. How do you react then to the bill that has been tabled? I think the measures aren't enough. They will not protect personal information. As for the actual approach taken in tabling this bill, I'd say that the bill gives banks more flexibility, with the idea that new technologies require this flexibility. Now, I'm not an expert in this field, but I would say that if the government and Parliament think that this additional flexibility must be given to banks as the approach, then this bill should automatically examine what needs to be done to better protect consumers in this case. And I think that part of the formula is missing.
On the banks? No, okay. Okay. Then let's move on.
Maintenant, peut-être que le Sénat
Perhaps Senator Maura would like to follow up.
Comments. I think all of you suggest that PIPEDA should be enhanced to strengthen our privacy laws, and I must admit I can't disagree with that. I think it should be done there, including bringing in political parties. My question to all of you is that comprehensive enough? What happens if companies don't sign PIPEDA or not required to sign PIPEDA? What about the Amazon Alexas of the world, or the Google Homes of the world, or the Internet of Things, where, yes, they're providing you a service, but let's face it, they're collecting data. They're going to use that data to do an analytics, to sell it to somebody. That's not covered by PIPEDA. How do you cover off your privacy on those issues?
You want to start with Mr. Kardash, and then we'll move from there?
So thank you for your question. Every day we get questions from companies, especially foreign-based companies, who ask us what laws will apply. So in all the examples you just gave, to the extent, and it sounds like there would be, personal information processing of Canadians carrying on business in Canada, PIPEDA would apply. The full range of the obligations on PIPEDA, from the organization being accountable from the moment it's collected or created until it's destroyed, getting lawful authority, usually by consent. There's some exceptions to consent. Safeguarding obligations. There would be rights of access afforded to individuals, data accuracy obligations, rights of correction, and as well as the rights of redress, including the right for individuals to complain to the Office of the Privacy Commissioner of Canada. So there is an existing regime, and it would apply to those types of circumstances, which should give comfort to folks who have queries about that particular type of matter.
What about health and pharmacies and all of that whole sector? Is that covered by PIPEDA as well?
Well, there's provincial health privacy legislation that would cover. In Canada, while there's often a focus on PIPEDA or public sector, there's actually 33 privacy statutes covering the private sector provincially, federally. There's health sector. So pharmacies would typically be covered by applicable health privacy legislation, which are quite rigorous in many respects, so they would be.
We'll get the response from Commissioner Therrien.
So yes, PIPEDA applies with all its virtues and flaws and weaknesses. So when companies based outside Canada do business in Canada, largely PIPEDA applies and provincial law may apply. And then a lot of very sensitive personal information may be collected by these personal assistants or technological assistants. So I think we need to focus on what kind of information is collected and to what end is that information put. Adam, with whom I agree a lot in his remarks, says that he's not so sure about opt-in or explicit consent as a rule, and I would agree that opt-in should not be the automatic rule. But when a personal assistant collects the conversations or the commands of a person at home, there will be a lot of very personal, very sensitive information being collected. And there, explicit consent should be obtained by the customer. So essentially the contract should say, Madam or Sir, you're going to receive all kinds of advantages through this personal assistant that will be very convenient, and we will be collecting some very personal information about you. Do you explicitly consent that we do that and that we use it for purposes A, B, and C? So consent has to be reinforced, having regard to the kind of information being collected and the uses it will be put to.
Okay. Dr. Levin?
I think perhaps the problem is PIPEDA applies, but that doesn't mean really anything. PIPEDA, as it is right now, does not give the commissioner the power to do anything. So you can say, okay, there is a law, and you can complain to the commissioner, and the commissioner can investigate. and find that your complaint is, as they say, well-founded. But that's it. The commissioner does not have the power to order the company to stop doing what it's doing. The commissioner does not have the power to impose a fine on them, as we've just seen introduced in Europe, and we've seen almost immediately, I think, 3 or 4 lawsuits, big lawsuits in Europe, against the big companies for being not in compliance with the new law. So we have none of that in Canada, and the commissioner has been calling for those powers, like I said, for years and years and years. So it's one thing to say we have a law, but it's another thing to recognize the law has no teeth. And if you really want to protect the privacy of individuals, then what you need to do is give the law some teeth that the commissioner can use if it's so required. Because right now what you can do is basically you have a complaint that's been well-founded, and you can now pursue other legal actions in court. But that's the end of the assistance that the commissioner can do in their regulatory capacity. So I think that's the big problem with the law as it stands.
Okay, we got a point of contention here. We'll go to Dr. Steeves, and then we'll go back to Mr. Kardash for a final comment.
I think that thinking about what kind of data is being collected is really important, but it's not just about the data. It's about how that data is actually processed. So you look at Alexa, you look at Sidewalk Labs in Toronto, you look at smart fridges that decide whether you need milk or not. All of that data is collected from all these different places, and it's put through an algorithm. And it's really important that we start to bring the algorithmic discussion into the privacy debate. Because the way these algorithms work is that they don't just assume you're going to do exactly what you've done in the past. They say, well, you're just like people like you that we've already identified in our algorithm, and we're going to assume that you're going to act like people like you have acted in the past. So it creates this open season on discriminatory outcomes. So we know that algorithms discriminate. We know that algorithms are more likely to discriminate and harm marginalized peoples at a higher level than non-marginalized peoples. So when we're talking about what we need to add to the PIPEDA toolkit, I think we have to add a demand that there be algorithmic transparency, that companies have to be liable for bad outcomes, and they have to be responsible for saying, this is how our algorithm works, and you know, this is how we can fix it. The other thing I think we can do, and it kind of falls within the opt-in or opt-out, I don't care if I'm opting in or opting out. Just let me buy a vacuum cleaner that doesn't put a map of my house on the internet, and let me buy a fridge that doesn't tell, you know, my grocer that I'm out of milk. I might not want to buy milk. I can't buy a car that doesn't tattle on me. And the reason I can't is because we're building these algorithms into our infrastructure. Consent will never get there because it's now an infrastructure problem. So let's make sure that as we innovate, although that's where I'm cynical, but we create these new systems that we allow people to not be caught up in this data stream.
I think that was my point. I'm just worried whether expanding PIPEDA will ever be enough. Yes, it needs to be expanded. I don't think anybody disputes that. We'd have to bring that into the modern world, but will it ever be enough? And I guess I like your concept of treating privacy as a human right. That changes the whole way you frame the discussion going forward and frame the regulation going forward. So
it's very important. And when the Feinstein Charter was introduced in the Senate, the thinking behind it was that a charter that set out specific rights would also put courts into a position where they could draw firmer lines around purposes. So when I say companies have free reign, sure, once they've got your data, they got to do all sorts of stuff. But if you press that click through consent, and they've said, Val, I'm using your data to serve you better, there's really very little I can do when it gets into Cambridge Analytica's database because I've consented.
Can we get a quick final comment from Mr. Kardash, and then we'll move on to our next senator?
Okay, for now, we can move on.
Oh, okay.
We've got plenty of opportunity.
Well, I want to also welcome Nathan Erskine Smith, who's a MP from the Toronto area, and who's joined us at the table, and Senator Down next.
Thank you, Chair. I'd like to thank all the panelists for their wonderful presentation. I'll keep my questions short this morning. I'd just like to follow up and drill down with the Privacy Commissioner just on the restrictions that you currently operate under. For example, I read in the media in the last couple of days about allegations of misbehavior, if you will, of employees of the Canadian Revenue Agency, some of whom may have been looking at personal information on Canadian taxpayers. The story indicated there was reprimands without explaining what they were. What involvement, if any, would you have in a situation like that? Are you automatically informed by the agency? Do you oversee the reprimands? Do you find out what the reprimands are, or do you suggest them? How does that work?
We have actually conversations at a higher level of generality with departments on that issue. So we do not have order making for government departments any more than for corporations. But we did an audit of that particular issue, breaches within the Canada Revenue Agency several years ago. And I must say that the agency took some steps to try to remedy the situation, including using the disciplinary system against its employees. Of course, it trained employees and the importance of preserving personal information. Obviously, the story shows that there are limits to that training, and then discipline comes into the picture. But I do not oversee the disciplinary process. I'm relatively encouraged by what the Canada Revenue Agency has done in that regard, but not all departments are like this.
Do you know, for example, if taxpayers whose information has been exposed from somebody who should not have seen it are notified by the CRA, for example?
Less often than the taking of disciplinary measures. So here we get into the rule under which individuals or my office would be informed of such a breach is not a law, it is a policy of the Treasury Board. So there's no enforcement mechanism for that. And that policy relies on the notion of what is a significant breach of privacy and whether the breach would have significant consequences. So the department, here the CRA, the Canada Revenue Agency, has to determine whether after a breach has occurred, whether this will have a significant impact such that the individual needs to be informed. When we're talking about tax information, one would assume that generally the information should be given to the individual, but not always.
So the determination, and I appreciate you have a long list, I'll be sure. So the determination what's significant is left to the Revenue Agency. So if your neighbor works at the Revenue Agency and looks at all your financial information, they may determine that is not significant. It would be significant to you, but it would not be significant to them because there's been no outside exposure.
So you're right. You're right that a determination is made in the department. It is not made, of course, by the individual who caused the breach.
Right. Thank you. And the reprimand sounds serious, but it could be simply a note to the file of the employee as opposed to any.
Yes. But there's a range of disciplinary measures that have been taken, including, if I'm not mistaken, firings in some cases. Right. But there's a range.
But you're not made aware what those bunch are.
No.
Thank you.
Merci à vous deux. Sénateur Mercer.
Thank you, Chair, and appreciate all the panelists being here today. I just have one simple question. We continue to come back to this table time and time again with problems that are ongoing. They're not new problems, and we're talking about this problem today, and in a year's time we'll be talking about another problem. Is there a way for us to put in place a review process that will anticipate future problems for data sharing that takes place that we are aware of or not aware of via a technology that is in use today, but not in use today, but will be in use tomorrow? It seems what I'm anxious to see is that we come up with a fix that says, okay, there's a review that happens of privacy protection on an automatic basis, if it's annual or biannual or whatever works, so that governments can respond and say, okay, this is a new technology, this is a new happening that's going on out there. How do we protect Canadians' information and, obviously determine whether Canadians want that to be protected? But it seems to me we should put this in a situation at the end of the day where we're not back here talking about this problem in 2 years' time, but we may be back here in 2 years' time reporting on what the process has come up with to help protect Canadians' information.
Qui veut?
Mais pas nécessairement le premier.
Who wants to go ahead? I will, but not necessarily first. Okay, who wants to go first?
The Act has a provision, a helpful provision for a mandatory 5-year review of the Act. It's repeated. The Act came into force in 2001. There's been one review completed. One. That's it. So the process is actually established. It just hasn't been implemented. So it was established, and I think a 5-year time frame is probably appropriate. It would take into account the changes, probably material that would take place in the data environment. But you have a statutory provision for a mandatory 5-year review. There just has to be. It has to take place. It hasn't taken place. Only one review.
Commissaire Therrien?
Commissioner Therrien?
A statutory 5-year review, that would be an excellent start. But I think your question is aligned to what Adam Kardash was saying a few minutes ago, which is, I'm sorry for my answer, but my answer will be, it is not possible with the evolution of technology to ensure that the law that will be adopted in 2018 will work in 2023 or 2030. The nature of the beast is that technology evolves, which then brings us to the point that Mr. Kardash was making, with which I would have some nuances, which is, what is the appropriate legal framework for an area that is in constant and very rapid evolution? PIPEDA is based on general principles, is sector neutral, is meant to be a law of general application. I think there are advantages to that. It makes sure, it ensures that we have a framework which can anticipate, even though it cannot define them ahead of time, can anticipate future technological developments. The problem is that it is written, because it's very permeable, it is written in such broad language that it soon becomes meaningless. Consent is meaningless. Accountability is not meaningless, but it's in the eye of the company that applies accountability. So there needs to be mechanisms to bring the general principles down to earth, applicable to different technologies, evolution of technologies. What are these mechanisms? That's a very crucial and complex issue to look at. In part, I've been suggesting that since we act for the public at the Office of the Privacy Commissioner, that we can play a role in bringing the high level of principles down to earth by playing an inspection role. So that's a part of the solution. I'm not certain that it's all of the solution.
Some leadership can happen around the tables in this place, both in the House of Commons and in the Senate, where commitments can be made by the organizations, particularly political parties, that they will show some leadership in management of their own lists, which are significantly large, and if a party does comply, I think that someone should say that, and they get a check mark beside their name, and the parties that don't comply will not get that check mark. But also, it should be known publicly that party X or party Y is not complying or is complying, because there are some benefits to supporters of political parties knowing that their party is following their wishes.
So leadership, I agree that leadership, or in the words of PIPEDA, accountability, are important, but I do not think it is sufficient. There needs to be third-party verification.
That's why I asked, is there a way for us to come up with some kind of recommendation that we have an annual or biannual or every 5-year review, perhaps directed by the Commissioner's office or by a special committee of Parliament, and perhaps a joint committee of the House of Commons and Senate, that would review it automatically as the technology changes and the methods of sharing changes.
Okay. Does anybody else want to jump in on this, in addition to the commissioner? No? Okay. Well, let's move along then to Senator Cordy.
Thank you very much, and thank you very much for your presentations. They've been very helpful. Scary, though, in some ways. I'd like to go back to the issue of what exactly is informed consent. And I know, Dr. Steeves, you spoke about you might sign off on one item of informed consent, but does that mean it's forever and ever? And does that mean it's for everything that's ever on Facebook? Or going back to your point about, somebody told me that my security system at home, which has inside cameras, that I should really put little covers over them because maybe people are actually following it, or the refrigerator that tells you that you need milk, or you fly into Ottawa on Monday morning and suddenly your iPhone is filled with ads for Ottawa hotels and restaurants. Then you fly back to Halifax on Thursday night or Friday, you get all the ads from the Halifax hotels and restaurants. So it's pretty scary because people know where you are, and they say, well, this is a good thing if you get lost or whatever, because people can maybe find you if you've got your cell phone on. But I guess it's, what is informed consent? How are you ensured that what you sign up for? And Dr. Levin, I think you presented some really good things for Facebook, the 3 options that you could have. And if nothing else, I think that would make people realize when they looked at the 3 options how vulnerable we are to people accessing your data for hopefully good reasons, but we know not always good reasons. So where do we begin with that whole issue?
Dr. Levin, and we can move around. Anybody else want to comment?
Sure. Thank you for your question. Maybe I'll say a few words about consent as how I understand it. So consent, people thought about it as this kind of bedrock principle that sort of showcases our autonomy and our control of our personal information. But since the time that concept was introduced as one of the fair information principles, 40, 50 years ago to today, you've seen the notion lose pretty much all of its sort of like protective power. And what has happened to this notion of informed consent is that it has changed into a tool that allows corporations to protect their themselves and to ensure that they're not legally liable. So it's a tool that, from protecting us as individuals and allowing us to think about what we want to share. And you can think about the old-fashioned sort of discrete one-time situations, right? Not the continuous data collections, but the situation where you'd walk into a brick-and-mortar retailer and they ask, can I get your telephone number or your postal code? And you can say yes or you can say no. And that's like the idea of, oh, I have the ability to consent, to agree, and it's a one-time thing. We're not in that world anymore, right? And so what the tool now does, and as other colleagues have said, it simply is a tool through which companies control their liability. And once you sort of agree to it, and we know in law we call these contracts of adhesion, or we use them not just around privacy. These are legal tools that businesses use to protect themselves from liability. So the question then becomes, if that doesn't work, then what do we replace it with? So we have to think about alternatives. And my suggestion for Facebook was, well, if and you have to think about, I would say, about the business model. So if the business model is around the data and monetizing the data, then if you want to protect individuals, think about protecting them in terms of that business model and offer the companies another way to make money, but that would give people meaningful choice and meaningful control. So that's why I said, well, you can do 1 or 2 or 3 options and you can require them to do that. But others have just said, well, you know what, you can just have, some legal standard of what is the reasonable processing or the reasonable collection or the reasonable use of information, but just have the regulatory powers to fine or impose a sanction at the end of the day if you conclude through an investigation that what they have done is outside of the scope of what they were intended to do. So that would be a model in which you don't necessarily have to click on these things that are becoming sort of more and more meaningless. You say, well, we give up that sort of kind of pretension that that's what we're doing, that we're agreeing. We're recognizing that there's a lot of information collection going on, but we're going to come out at the tail end and say, well, that's something that you shouldn't have been doing, and therefore we're going to fine you or sanction you or order you to stop doing that. And we right now, in Canada at least, we don't have, you know, we're sort of caught in the middle that we don't have either, right? We don't have the ability to order them, to sanction them, or to fine them. And we're still stuck in an option in which, you know, we say, well, you know, let's just find ways to get people to meaningfully agree. And I think we've got to work on it from one end or from the other end. That would be my comments. Thank you.
Anybody else want to jump in?
Yes.
Mr. Carter?
Thank you for that question. Let me share with you the questions we get, the exact type of questions we get from our clients, and I think it'll help provide some context in terms of what is consent and how it fits in with overall privacy protection. Companies, and I understand the comment about the protection of liability. Every single business and individually, we all should protect liability. I think that's important. But companies come to us, and in essence, they don't say these with exact words, they say to us, how do we respectfully treat data? Help us do this, because what we're in now is the trust business. So we have every single company in all sectors suddenly coming to us saying, we used to be that type of company, but now we're a data company. Every company is saying that. So as they do this, they're looking at their corporate values, and they're looking at trust as critically important for their long-term sustainability. And they realize that a respectful treatment of their employees' data, of their customers' data, the pharmacy customer data, patient data is critical. So when it comes to that, and if you frame the answer to how we assist, and you look at consent, well, first of all, the law actually is quite clear. The PIPEDA has been amended. There's this provision, 6.1, that talks about what is a valid consent, and it would put you in a position where you could understand the nature of the personal information and the consequences of that. And then there's a series of provisions in the schedule to the Act that set out, you know, when you have to, when it's implied and when it's expressed. The issue with it is in an incredibly complex world, and in a world where people are very busy and want to get on with things, and in a situation where the types of data flows that are required for very simple, wholly legitimate things, it's very difficult to write down. I draft these things for a living. It's incredibly difficult. You have to articulate complex data flows that are driving our entire economy and articulate that, and you're supposed to focus, Dr. Steeves would have a better view on this, I think it's grade 6 or grade 7 literacy rate. You try to hit that rate. That's what you're intending to do. And so it's a very difficult thing. So what happens with the concept, when you get this stretching of this concept for informed consent, is you have to put people in a position where in everything they do, countless times a day, there's personal information processing. They have to have the appropriate notice to be informed. So that's a challenge. There's ways to do it, and companies are doing an amazing job. There's excellent guidance from the Office of the Privacy Commissioner about concepts of layered notice and focusing on the stuff that would be a surprise and giving more detail but fulsome, meaningful notice. But the bigger challenge that we're finding with consent is a valid consent is revocable in whole or in part. So obviously, if you give your permission, you have to be able to say, I'm taking it back. Well, in many contexts, that works fine. I'm something simple. I'm going to be on a marketing list. Take me off. I don't want to check a box or press unsubscribe, and you're removed from the list. But when we're in an environment right now, and I urge the committee not to think about now. Think about all the amazing things that are happening now. Fast forward 5 years to an environment which data is ubiquitous, is absolutely central, embedded in the structure, as Dr. Steeves talks about. And if you talk about a concept of informed consent and revocability, it's difficult to manage. It's difficult. I'm not saying organizations shouldn't do it. It's difficult. There are 2 reasons for the difficulty. One in particular is that there are a type of data processing activities that are obviously becoming more sensitive, but that are critical to the function of businesses. So, for example, data analytics, and especially now with the use of artificial intelligence, it's incredibly important that all businesses, especially small business, growth, driving jobs, takes advantage of these amazing new features to provide new products and services. This is the core to the future of the economy. They're able to do this. if you were providing an opt-out categorically, like a withdrawal of consent for companies to understand their customers, it might sound, well, why can't you do that? It's very, very difficult to operationalize in any meaningful way. It's very, very difficult. So what we see companies starting to do, and this will be a challenge, and it will take time, and it will take these types of discussions, and it will take a lot of work by organizations, is that overall everything's moving away from consent being perceived as the primary means of enforcing privacy. There's a movement towards governance, respectful treatment of data through a holistic approach. Corporate governance, imagine data governance, same piece. Respectful treatment of data through the life cycle. All sorts of things are built within governance. Transparency, and I couldn't...
need to move on.
I will. I'm very sorry. I'm sorry. All sorts of things get moved into that, and that could be very helpful. I apologize for going to that.
Okay. Okay, Dr. Steve.
I agree that when we use consent as an on-off switch, it causes those kinds of problems, but I think that there are easy ways of remedying that. For example, we can use privacy settings and have them all set to, by default to private. So the most compelling argument is on devices and apps that children use. And I did an analysis of the 50 most popular a couple of years ago, and only 13% were set to private by default, which is stunning when you think about it. So if we set it to private by default, then your phone isn't going to be tattling on you unless you want to use a GPS. So I think that there are ways of building it into the infrastructure. I think when we talk about the problems with consent, it's very important that we don't get rid of consent, because we can't replace consent with governance, because that means the floor is gone. Like, we didn't want consent to be the ceiling, but if it's not the floor, then I think that's really problematic. I think consent is going to be with us for a long time for good reason.
Okay. Well,
Very briefly.
yeah. The.
No, Commissaire Therrien wants to.
Oh, I'm sorry.
Very briefly. I'll read into your question of what is meaningful consent, and I don't know whether that's correct or not. This is so vague and difficult to define that is it an appropriate basis from which to proceed? And to that, I will say, as Val Steve just said, that we, even though it is not a perfect solution, we should not get rid of that as part of the solution. And what I want to add is that before we issued new draft consent guidelines last week, we proceeded to consult various stakeholders from industry, consumer groups, and so on. And it was very clear that the vast majority of people we consulted want consent to continue to be part of the process, because it does protect autonomy in some cases. Now, it will not always work, but there are activities where consent may work if properly informed, and we've done a bit to try to define meaningful consent in guidelines. That said, it will not always work. In data analytics, in artificial intelligence, there are huge challenges in having the consent model apply, which is why our report to Parliament last year suggested that Parliament should consider seriously other lawful grounds to authorize processing, such as legitimate interest, which exists in Europe under the new GDPR that everybody's talking about. So in Europe, consent is not the only ground for processing. There are other grounds for processing, and the overall structure, I would suggest, is a robust structure. So that conversation needs to occur.
Okay, we have three from the table, Gagné, Joyal, and Erskine Smith, and I have one from the audience so far. And again, I'd remind you, let Sarah know if anybody else wants to join that one person.
Sénatrice Garnier.
Merci beaucoup pour.
Senator Gagné, thank you. Thank you very much for your fantastic presentations. I think the answer given by Mr. Kardash to Senator Cordy's question opened the door to the entire question of professional ethics. I'm wondering if the current legal framework provides tools to ensure self-regulation, ethical self-regulation of businesses. I think more should be done. I think we can improve these measures. Since the 1970s, we've attempted an environment that is much more ethical. In businesses, in organizations in Canada, that is. I listened to what you said about the limits of professional ethics with regard to this whole question of data protection.
Answer first. Commissaire Therrien.
Alors oui, il y a des limites à l'éthique.
Yes, there are limits to the notion of ethics. It goes back to the question of accountability in PIPEDA. I believe that many companies are trying to act ethically and certainly legally. They'll develop procedures that will help them to do so. In some cases, this will include ethical rules, a code of ethics. In the health sector, for example, hospitals and so on will have to consult ethics committees to learn how to properly manage sensitive data that they have to manage. Now, that's a good thing. It's necessary, but it's not enough. In particular, when we're talking about commercial organization whose purpose is, of course, to make a profit and to make profits for their shareholders. That's their priority. Legally, ethically, ideally, but their first priority is not to act ethically, it's to make profits. There have to be state organization and independent parties, third parties, that ensure that these principles of ethics and accountability are applied in a way that truly serves public interest.
Thank you, and Mr. Chair, I promise to be briefer. Thank you for your question, Senator Gagné. Two quick comments. One, in the vast majority of circumstances, just anecdotally, companies are now expressly telling us that their long-term sustainability there is an existential issue for them to conduct themselves ethically with respect to the treatment of data. Like, it just is now becoming a very interesting and helpful part of the discussion. So I will say that. Two, what's very interesting is PIPEDA has a principle or provision, section 5.3, that was cited before. Organizations can only collect, use, or disclose for purposes that a reasonable person would consider appropriate. And there's some interesting discussion now about what constitutes reasonableness, etc. We derive some understanding of that from case law, including Supreme Court of Canada case in Spencer, when there was excellent articulation by the Supreme Court of Canada about the concept of normative values being embedded into a concept of reasonableness, expectation of privacy, etc. So we're seeing this discussion move. And third, and I think most important, and to the absolute credit to the Office of the Privacy Commissioner of Canada, it has funded two projects that are focusing on this concept of data ethics. We served, our firm, I was involved, served as counsel to these efforts by the Information Accountability Foundation that explored concepts of what are some ethical considerations, what are the types of questions that organizations should ask as they do their data impact assessments to consider broader ethical concerns. And now there's a second funded again by the OPC, to its credit, considering about, well, how do we provide oversight for this in a private sector context? Unlike academia, where there's a research ethics board, right? How do we do that in a way that works? So there's a lot of discussion, I think very helpful discussion happening. I stop now.
Merci. Thank you.
Is there time for one comment or no? Yes? Okay. What I would add is I think the basic ethical question, given by what the Commissioner said, that businesses are in it to make money, is how are you going to make your money? And I think there was an exchange between the CEOs of Apple and Facebook, and the CEO of Apple said, you know, you have a choice to make, and partially it's an ethical choice. Are you treating your customers or users as the product, or are you selling them something? And when you're selling ads to other companies, then your customers become the product. And when you're selling the customers a service, whether it's social media, which has great value and great social benefit and part of people's lives, and if you sell it as a service, then it's a different business model. So I think the foundational ethical obligation is to see what are you doing as a business, and then making sure that you're giving people the options within that environment. And then you can talk all you want about down the line, but that's, and you know, and he said it clearly, we made a choice to sell a service, and that's what we're charging for, the CEO of Apple, you know, and Facebook made a choice not to sell the service, but to sell the customers. And that's where they ended up.
Dr. Steves?
I so agree with what you just said. I just wanted to quickly add that the three funding councils that do govern academic research have done a lot of thinking about the ethics of big data research, so it's a resource that would be useful to look at.
Thank you.
Okay, I'm going to insert one person from the floor at this point in time, and then come back to the table. If anybody else wants to go down on our list, let me know. We have Pierce White Joan-Guess from Carleton University who has a question. I hope that microphone's up for
Tall guy, sorry. Thank you, Mr. Chair. Thank you, honorable senators, and thank you, distinguished guests. My question centers around the senator's question around consent, and more so across Canada and even globally, consent is defined differently, and each legislation has a different definition of consent. So I'll take Canada, for instance, under the anti-spam legislation. Consent is defined differently than it is under Ontario's public sector privacy law. So I guess my question is, and this is for all the panelists, is where do you see the framework, the legislative framework moving forward for these consents being mismatched across the different legislations? Because if I collect consent under CASL, it's not going to be the same I collect under GDPR or under Ontario's FIPA. So that is something that I think organizations are really struggling with, myself included, because I've got 5 privacy legislations I'm responsible for: GDPR, CASL, Ontario's FIPA, Ontario's Health Information, and the federal PIPEDA law. So right there, I've got 5 different avenues of how I'm getting the personal information. So my question again is how do we envision the future legislative framework to ensure consent is the same across the board? Thank you.
Okay, who wants to start with that? Okay, Mr. Kordash.
Well, I can tell you one of the things you described is becoming the increasing challenge with, as I mentioned, there's 33 statutes here, and there's different authorities under each that allow for the processing, and they will vary. And so what companies have to do, in the absence of pure harmonization amongst the statutory frameworks, companies have to take steps on a data flow by data flow basis, understand what's taking place, the data that's involved, and consider what statutory frameworks would apply. It's quite common on a day-to-day practice that 2 or 3 different statutory frameworks, if not 15, would apply to a given framework. Now, having said that, all these statutory frameworks are grandchildren of OECD principles, and there is a general consistency, and the consent principle generally is, for the most part, a codification of common law concepts of consent. So a lot of the stuff gets there, and PIPEDA actually sets a pretty good starting point. Our practical experience is if you adhere to the PIPEDA standard, you're pretty good. GDPR is way too prescriptive. The guidance coming out of the GDPR is mind-boggling. But for the most part, that's a good starting point, and then you got to go statute by statute.
Who else wants to pick up on that? Okay, Dr. Steves.
As Adam mentioned, the Supreme Court of Canada has taken the position that privacy is a normative concept, and I think that principles matter. So I would go back to an umbrella statute that made it very clear that privacy was a human right, that gave it some context. So each piece of legislation underneath that umbrella could be interpreted in a way that would allow for uniformity and certainty. And in that regard, I'd point to an early work in Australia, although it was never legislated. The Australia Privacy Rights Charter is an excellent articulation of those principles.
Commissioner, do you want to weigh in on this? No? No? Okay. Hope we got the answer to your question.
Prochaine question, Sénateur Joyal.
Senator Joyal, thank you, Chair.
On the issue of the European regulations, that according to the note that has been circulated, that protect in fact the users so that the users could know, understand and consent to the data collected about them, and that they have the right to correct inaccurate information. That's the European regulation that is implemented, starting this week or 25th, last week. I feel that the proposal of the government to regulate the information collected by political party more or less reflect that, but doesn't protect the use of the aggregate information that represent the fact that having a bunch of information on a group of people, that bunch of information has a marketing value, and that they use that bunch of information, that aggregate information, the way they want, as Cambridge Analytica, in fact, did. They had access to the aggregate of information, and they could use it, they could trade it, they could sell it, they could benefit from it, they could intervene in the political system and whatnot. So it seems to me that the proposal that we have addresses only one aspect of the reality from the one who use the internet or the Facebook and all the other internet services through which a consumer can have access. It protects to a point the consumer, but it doesn't protect the fact that the whole of those information represent the marketing values, and they can do with it whatever they want with it. So it seems to me that there is another step that you have to take to be sure that, as Monsieur Therrien has said, that your legislation is not outdated the very moment that it is adopted, because the internet services have found another way to better benefit from the aggregate of information that represent the total of all those information in the system. So that seems to me to be more the conundrum than anything else, because protecting the rights of a citizen to control his or her information is very similar to PIPEDA as it is today. My information are protected. I have a complaint. I can address myself to you, and you do an investigation, and then you propose some corrective measures. But the fact that there are X millions of people who have put their information together at the same time in one internet service, this represents a resource that is traded, that is sold, that is used, and you have nothing to control on that. That's where I think the major challenge of protecting personal information lies today, unless I don't understand how the system works.
So is it the major challenge? Who wants to go first? Commissaire Therrien?
Je peux commencer. I would certainly agree that the proposal in C-76 is extremely incomplete in terms of privacy protection. And just on your point, Senator Joyal, of aggregating and analyzing information, actually, when I look at the relevant clause of Bill C-76, all that the bill proposes is that parties publish privacy policies, and here I'm into 254 1K sub 5. The policy must give a statement indicating the party's practices concerning the collection, use of personal information created from online activity. So all that the party needs to do is to disclose the way in which it will collect and use, including potentially analyzing, aggregating, etc. It doesn't say anything as to how this should be done. So a party could disclose this in very consumer-friendly terms. We will use your information to know more about you, to better meet your interests as a citizen of this country. So this is essentially meaningless, I must say. It's a statement It doesn't say how prescriptive the information needs to be defined. There is no link, as our presentation suggests, between the elements of the policies that C76 mandates and the international principles or the PIPEDA principles that exist. And moreover, there is no third-party supervision or oversight of whether these rules are actually applied on the ground. So it is a start. C76 is a start, but it is a very, very incomplete start.
Yes? Yeah. Thank you. What I would say is the concerns that you raise are the reason why I think we should have as individuals the ability to have what I call the information-free version about our data, and whether it's political party or a commercial service. We should be given the ability to clearly tell whatever the entity is that we want to opt out of our information being processed. Because the issue about aggregates has usually been resolved saying once it's aggregated and anonymized, then you don't have to worry about it because it's not about you anymore. It's about some kind of a profile of, let's say, a white male in his 50s who lives in Toronto, and then that's not you. But of course, the business model is try to make it as close to you as possible so we can learn all those insights. And I think we're at a point, especially if we're looking forward with respect to artificial intelligence and big data and more powerful algorithms, that we have to at least give us as individuals the ability to say, I don't want to participate in that. Now, there might be some consequences. I might have to pay if it's a different kind of a service or whatever, or I might not get the ads when I travel to and from Halifax or whatever. But that's the trade-off that maybe I choose to do. And I think that would go a long way in terms of addressing those concerns as to what happens with respect to aggregate data. I don't think that the argument that it's anonymized, therefore you don't have to worry about it, is as powerful as it was, let's say, 5 or 10 years ago. Thank you.
Thank you.
Merci.
Okay. And finally, Erskine Smith, Nathan Erskine Smith, our MP colleague.
Thanks very much. I'm representing the House, I suppose. That's right. So for those who don't know me, once upon a time when I was an articling student, I did a little bit of privacy law, but now I am the vice chair of the privacy committee on the Liberal side, and we tabled a report in February that made a number of recommendations to improve PIPEDA, and we're actually undertaking a study right now on the Cambridge Analytica and Facebook breach, including having Christopher Wiley before our committee for 3 hours yesterday. And so there are a number of different questions I might have, but the one question, we made a number of recommendations, and you've heard a lot of commentary today that is consistent with the recommendations that we made. There's debate to be had, though, about, Mr. Carter, you mentioned GDPR being too overly prescriptive, and I think people can have reasonable debates about how we ought to regulate commercial entities and political parties going forward, but where it didn't appear to me to be any reasonable debate is that wherever we land on what appropriate regulations there are, we ought to have enforcement powers or proper powers for the Privacy Commissioner to enforce whatever regulations we arrive upon. And so we made recommendations, 4 recommendations in particular for enforcement powers, and I wonder if the panel could speak to those specific recommendations. One is to allow the Privacy Commissioner to make orders. One is to allow the Privacy Commissioner to levy fines, and I'd be interested in understanding the views whether the GDPR fines are effective enough, whether the UK system of £500,000 is effective enough, or our more modest BC model. We made recommendations to give the Privacy Commissioner discretion to pursue complaints or not. I mean, only $25 million shop and big players that he's got to regulate, so has to allocate resources presumably as they see fit and can't pursue everything, and then broader audit powers, so not only respond to complaints. And so I've spoken to previous privacy commissioners who have made the point eloquently, I think, that where companies make money using data, they ought to lose money where they misuse data. And so I wonder if the panel could speak to that.
Wow, that's an awful lot to cover, but let's have a crack at it. Who wants to start? Oh, okay, Dr. Levin.
So I have a simple opinion in response to the committee's work, and I agree with all of your recommendations. I think they are long overdue. I think they've been asked for, not since the latest scandal, but for at least, I think, since the first Pepita review. And so I will stop there. I think the time has come. And as I said in my comments, it's a question of political will. And I'm really looking to see whether our elected representatives will act. I know the committee recommends, and government decide, and then the relevant ministry will see what it does. And it's a question now for the government of the day to see whether they're going to take action on that, because it's about time. Thank you.
Anybody else on this?
Sure.
Dr. Curtis.
Okay, Mr. Carter. We'll go around.
I think it's really important to have a fulsome discussion about not if, but the nature of the different enforcement powers. I think we have an opportunity here in the country to forge our own way. I increasingly, as we've been dealing with sort of the GDPR and other foreign regimes, I'm coming to think that we have a pretty good model here. It definitely needs some change. We've already discussed some of this. And it's possible that certain types of enforcement powers, targeted, proportionate, etc., could be helpful for that. I want to share my anecdotal experience in dealing with clients across multiple sectors, dealing with investigations with the Office of the Privacy Commissioner of Canada. They currently have an arsenal of powers. They have been, in my respectful view, stunningly effective over the course of the years. The vast majority of investigations where we're acting ends up with companies, first of all, saying, we're not worried about the fine. We're worried about the adverse PR. We're worried about our trust. And before the investigation is even completed, they have carefully examined their practices and enhanced those. That's what's happened in the practice. So even the mere commencement of inquiry has been really, really effective. What I would urge, and I think it would be very, very helpful to hear in due course, are the circumstances where the lack of enforcement of powers has proven problematic, because that will be extraordinarily helpful in the shaping of the types of enforcement that could be helpful in dealing with, again, for particularly egregious types of circumstances. I just think we have this wonderful position. We're close enough to the U.S. that we understand we conduct business like that, except we have a model that's fairly close to Europe, yet there's a lot of things we can do our own way. So jumping to, for instance, the extreme penalties under GDPR, I don't think that would achieve the goals that we ultimately deal with in terms of the privacy protection. Okay.
Dr. Steve?
Good and corporate intentions aside, all of that data is worth huge amounts of money. It's incredibly tempting to grab it. For example, the OPC has a policy statement on its website saying that no organization should use online tracking with children. And yet, I did an analysis of the top 50 sites, and 96% of them use trackers because it's really, really profitable information to collect. So I would second the earlier comments around the panel. I think orders, fines, and audit powers are absolutely essential.
Commissioner.
Not surprisingly, I agree with these 4 recommendations.
A few words.
My friend Adam Kardash talks about brand reputation as being very important, and it is. But we're also hearing from many parties of industry elsewhere in Canada, outside Canada, that for the corporate world, for presidents of companies, knowing whether they are under liability of a fine versus exposed to recommendations from a regulator makes a real difference in terms of what kind of resources they will put to privacy protection. In clear terms, not being liable to fines means that they feel they can spend less resources for privacy protection. We are hearing that time and again. I do not dispute that brand reputation is important, but it's not everything. So I think orders and fines are necessary in some cases, because not every company will want to act responsibly, and some generally responsible companies may err, and either because of the lure or profit or other considerations, may fall outside the line. So this is necessary. If we were to have these powers, this is not to mean that we would rush as our first activity in dealing with companies and organizations to use them. We would continue to try to work with organizations to bring them towards compliance with the law, with public education, with guidelines, with advice, because I think it is not effective as a regulator to hit people over the head and impose fines as the only or first or primary strategy to bring about compliance generally. So we would continue to be cooperative, to work with companies to bring them towards compliance, but that is not sufficient as a strategy. I'll stop there.
Okay, let me ask our colleague from the House a question about what is the status of those recommendations, the report that you came out with in February? Where is it in the system?
So we're still waiting on the government's response. They've got 120 days to table their response to our committee report.
Okay. And C-76 also plays into our discussion today. This specifically deals with, it's the Elections Modernization Act, and it does have provisions which the Commissioner has commented on, and we put out an information sheet on this about what it covers and what is absent from coverage in that. That's through your House, I think, now. It's into ours?
It is through our House. And just the only other comment I would make to C-76 is, so out of this Cambridge Analytica study that we're undertaking at the moment, we're likely to have a further recommendation about the regulation of political parties under privacy laws. We had both the BC Commissioner and the UK Commissioner before us, and they both said our laws apply to political parties and democracy still functions in the UK and BC. So I expect to see that conversation continue in our committee.
But these provisions in C-70, they don't bring political parties under PIPEDA.
They do nothing other than require political parties to have privacy policies.
Okay. All right. I think we're finished. Most interesting discussion. So, colleagues, what we need to think about is how we want to advance it in the Senate from here on. We do have C-76 coming our way now for consideration. Let's have a very close examination of that in terms of what it covers and what it should cover and doesn't cover. And then also think of how we might assist our colleagues over on the House side in their efforts to bring about the kind of reforms that we heard the committee come out with in February. So it's been a very useful discussion. It's useful even more so if we follow up in some way. Closing remarks, colleague?
Je pense que nous avons vu ce matin.
I think this morning we saw the importance of protecting the democratic issues. It's important to act properly, but faster too, given the tremendous development of data collection by businesses. As Senator Eggleton just said, we at the Senate must find a way to take a good second look at this question as soon as possible. Thank you very much for raising very interesting questions and solutions. Our review of C-76 will hopefully be a wonderful opportunity for us. I see Senator Mercer would like to have the last word. Why not, Senator Mercer?
Colleagues, I just wanted to make sure that we expressed our gratitude to Senator Eggleton for his leadership in this program that we've been through since he'll, believe it or not, turn 75 this summer, and we'll have to leave the Senate, and I wanted to make sure that we publicly thanked him for all his work, along with Senator St. Germain, and also to indicate that Senator Cordy from Nova Scotia will take Senator Eglinton's place at the head of the table at our next meeting.
And we'll be happy enough, lucky enough to have him in September for
a short period.
The
One
last
more
edition.
meeting.
One more meeting.
Yeah, I won't go that fast. I'm here till the end of September. Anyway, thank you to our panelists very much, and with that, the meeting is adjourned.
Yep.